just a little background. I've been doing risk analysis for covered entities and business associates all across the United States for the last 15 years, and there's obviously been a very big change as of the September 23rd HIPAA Omnibus Rule when that went into effect. I've also served as expert witness on multiple court cases that have been going on here lately, since individuals are learning that they can sue under under their state law for wrongful disclosures of private health information, which is one of the biggest changes that we need to talk about, in addition to why we are here, which is the imminent federal audits, the proactive auditing that the federal government is doing now with this law. And I have worked as a outsourced contractor for the federal government, going after covered entities as well as business associates in an audit process. And I'm going to talk about the things you really need to look for when and if you're audited by the federal government, and things that maybe aren't quite as important, but nonetheless, I've seen this from both sides. Normally, I'm working on behalf of my clients, defending them from the federal government, but I'm glad I did get some insight as to how the audit process works and what the government is wanting to see, so I can see it from both sides. So without further ado, I'll go ahead and get started here. So the Health Insurance Portability Act, or HIPAA, for all, you know, the name in of itself is a bit of an enigma, because when most people think of HIPAA, all we think of is, you know, be quiet, don't disclose private health information, keep it secure, don't send emails in a non-encrypted manner if they contain private health information, don't text private health information, don't orally speak private health information, don't leave paper-based records turned up, yada, yada, yada. That's what we think of when the word HIPAA comes up. But the irony is, that's not what this law was even about from the beginning. It's called the Health Insurance Portability Act. So think about that. What it means and what the original inception of it was intended to do was that an individual would have some sort of health insurance that they could have. It would be portable from when you lose a job to when you pick up another job and get regular health insurance. So the government wasn't having to foot the bill. That's the original reason for the law, among other purposes, but that was a primary reason. It was signed into law in 1996 under Clinton and enacted by Congress that same year. It's also known to a little lesser degree as the Kennedy-Kassenbaum Act. I'm not going to spend a lot of time on the history here, but I think it's important that we build up to understand where we are now. So it was known as the Kennedy-Kassenbaum Act, named after its two major sponsors, Senator Ted Kennedy, Democrat, Massachusetts, as well as Senator Nancy Kasselbaum, Republican, Kansas. So we can blame both parties for all of our headaches here with this law. And in the acronym Health Insurance Portability and Accountability Act, nowhere in that acronym do you see the words privacy and security, but yet it's privacy and security that present our biggest challenge with this law in terms of how are we going to secure this information. So this law has been in effect since, for all intents and purposes, 2003. It was signed into law in 96, but the HIPAA security rule did not come out until 2003, meaning we must put in reasonable and appropriate provisions to limit the risk of wrongful disclosures of private health information. Well, it was put in back in 2003, but it wasn't really being enforced, and I'll get into that a little bit later. There was no funding. What good is a law, quite frankly, if there's no enforcement? So just another little bit of understanding of what HIPAA is in its whole is if we look at the 5 titles here, there's 5 individual titles for this. Title I, Healthcare Access, Portability, and Renewability. That's the main reason it came out, remember, for health insurance portability. Title II is Preventing Healthcare Fraud and Abuse, Administrative Simplification, and medical liability reform. You'll notice I have administrative simplification here in red. Why is that in red? It's because it's under this little subset of Title II where we find the Privacy and Security Act. That's under that little subset. That's where we find the privacy and security specifications of this act, as well as the coding aspects as well, the ICD codings under administrative simplification, which is a big irony because it doesn't really seem to have made anything more simple, but yet that's where it resides. Then under Title III, we have tax-related health provisions. Then Title IV, application and enforcement of group health plan requirements. Then Title V, revenue offsets. So again, of this entire law, and the entire law we basically think of as securing private health information, it's only under the administrative simplification aspects under Title II where we find privacy and security.